Hello again, folks. As promised, here I am again, ready to present to you the fourth part of, excuse me, Missouri allergies. They're horrible. As I refuse to do this again, moving on. We are moving on to the fourth part of the Judge Rotenberg Center on Trial, Part 4, back on April the 25th, 2012, by Shane Neumeyer. Trigger warning, what you are going to hear in this video is some descriptions of abuse and torture of a disabled person, as well as the defense of the torture and abuse of a disabled person. If you have kids, please put them to bed or put them in another room. All right. Moving on. The defendant's case in the ongoing medical malpractice trial over the long-term restraint and repeated electric shock of Andre McCollins at the Judge Rotenberg Center began on Friday the 13th of April with the testimony of Dr. James Riley, Attorney Edward Hinchy, representing Dr. Riley separately from the other defendants in the case, namely Dr. Matthew Israel, Dr. Robert Van Hain, and the JRC as a whole, conducted the direct examination over the course of the afternoon. The beginning of the direct examination provided the jury and observers with a sense of who Dr. Riley was and the work he had done for the JRC. He identified himself as a psychologist, a current acting clinical director at JRC. Earlier in life, he had served in the Navy as a flight officer and was on active duty in Vietnam. His experience there and serving during the Cold War in general made him very interested in human behavior, and when he left the Navy with the rank of commander, he went on to pursue graduate work in the field of psychology. The positions he has held since then have included professorship at the University of Massachusetts and the working for the Massachusetts Department of Mental Health as the chief psychologist at Bridgewater State Hospital. That's horrifying. As for his role at the JRC, while he has worked with the program for many years, he has never been a full-time employee and was serving as a consultant in 2002 when Andre was there, working Wednesdays and Friday mornings. He described the treatment philosophy at the JRC as one of radical Skinnerian behaviorism and told his attorney and the jury about the various behavioral interventions, including adversives, used there. This included providing a brief explanation about the legal substituted judgment process used by the JRC to get approval to use adversives on individual students, which involves the development of a treatment plan, parental consent, and review by 2 committees and a probate court. He also discussed JRC's positive behavioral program to some degree, calling it Reward Heaven. Excuse me. So stick and carrot. The rewards he mentioned ranged from relatively basic things like getting to listen to music or play sports to visiting the facility's big rewards store. Really? Rewards was basically let a kid be a kid? Okay. Like an arcade-like area where children can socialize in relative freedom and use points earned through the JRC's positive behavior program's token economy to play games and buy toys. Dr. Riley went on to characterize the population at the JRC students at the time Andre was attending, which he implied was different from the population that the program works with now, as people with intellectual and other developmental disabilities who had very disruptive behavior disorders that prevented them from leading normal productive lives in society. Says you ableist fuck. Moving on. I'm not even going to get in, or I won't stop. Okay. Moving on. In addition to describing the JRC itself, Dr. Riley explained some of the tenets of behavioralism in general, specifically the difference between counseling and behavioral psychology, and within the latter category, between cognitive or reasoning-based behavioral therapy and operant or consequence-based conditioning. When asked about whether a psychotic conditioning, I'm sorry, I have to stop. Conditioning. Does that not sound like brainwashing to you? Because it does to me. Conditioning. That's like gay conversion therapy crap. Sorry, I had to say something. Going back, when asked about whether a psychotic patient could benefit from operant conditioning, specifically the use of adversives, he said that psychosis was not in fact a contradiction for their use, as without conscious learning being required, a psychotic patient can still benefit from them. How? If you don't even know what you're being punished for, what's the point? God, I hate people. They shouldn't be punished for their disabilities in the first place. And that's logic. Moving on. However, as Mr. Hinchy made clear through his questioning of the witness, interruption of consequences in operant conditioning makes treatment take longer with any patient, as the lack of consistency will cause them to learn more slowly. Where it came to his involvement with Andre, Dr. Riley testified that he had not been the first psychologist at JRC to work with the boy, but rather had taken over from another doctor. However, he had designed Andre's treatment plan, relying on records from earlier residential programs and personal observations to identify target behaviors to be addressed through the use of adversives. You sick fuck. When asked by Mr. Hinchy, Dr. Riley named and explained the conditions with which Andre had been diagnosed with upon placement at the JRC, namely moderate intellectual disability, impulse control disorder, conduct disorder, pervasive developmental disorder, ADHD, and psychosis not otherwise specified, NOS. As for his personal observations about Andre's behavior and demeanor, he spoke of how there were two Andres. The boy could be very easygoing and relaxed or very aggressive. Might be because you're shocking them. He would talk about dark things, stern face, frightening guy. You really don't want to get me in a dark mood. You probably would have shocked the hell out of me. Just saying. Glad they didn't see my comics when I was younger that I drew. He went on to describe several instances of Andre's assaultive behavior against staff, including biting and at one point breaking a staff member's thumb. Gee, I wonder why. Dr. Wiley's testimony continued into the following week, with court resuming on Tuesday the 17th after a state holiday on Monday. Before it was continued that morning, however, there were a couple of motions made outside the presence of the jury by the parties. One of them concerned the fact that the members of the JRC staff could be heard laughing in the video footage while Andre was being restrained and shocked. Yeah, they laughed. They laughed while he was screaming and begging for help. Sick fucks. This video is not for children. Okay, I'm gonna have to find where I was. I'm sorry. Defense attorney for the JRC. Excuse me. And two of the individual defendants, David O'Connor, said that they had not expected the laughter to become such a big issue in the case. Are you kidding me? And wanted to repair the damage it had done by calling an additional witness, one of the people who had actually been there that day, to explain it. Specifically, if allowed to testify, the witness was expected to say that the technician in the room had made an off-topic joke, and the laughter heard on tape was not directed at Andre or his situation at all. The hell are they doing laughing in that situation? Specifically, if allowed to testify, the witness was expected to say that a technician in a room had made an off-topic joke, According to Mr. O'Connor, there may be things in a charged environment that make people laugh, and the jury had not heard the laughter in context. Plaintiff's attorney Benjamin Notvinny argued against allowing the witness to testify because it would delay the case and because he had not had the chance to speak with her in a deposition. He also questioned how the defense team had not realized that the laughter could have come up as an issue, especially since they had the video footage the entire case, and that particular part of it had come up repeatedly in depositions. The judge took the issue under advisement. At this point, the defense stated that they will call a member of staff who was present on that day to testify later in the case, and thus it appears that the defendants eventually prevailed on this motion. In a second motion, Dr. Wiley's attorney made a motion to be able to include evidence, a document that established that, as of June 2002, Audrey's treatment plan had been altered to include full-body tense-ups as a target behavior for which adversives could be administered. This is sick. According to Mr. Hinchy, this behavior was added under the category of harm to self. You're shocking him. Oh my. It was based on observation of Andre while he was at JRC. Mr. Novotny argued that this information was being brought up too late, but Hinchy stated that he had had no more idea that the relevant document had existed before this point than had the plaintiff. In the end, the judge decided that the document could be admitted to evidence. This is disgusting, seriously. No, but we have to punish him if he goes into full-body tense-up because he's not doing what he's told. You're shocking him. Tensing up is a body's natural response to such aversive therapy. Are you kidding me? God, I hate people. Moving on. Upon Dr. Wiley's return to the stand, the discussion once again turned to the subject of psychotropic medication. Of course it did. Dr. Wiley testified that the JRC discouraged and sought to eliminate the use of psychotropic medication on students placed at the program because of the very severe irreversible side effects that they could have. You mean unlike shocking them nearly to death? Because I'll take the drugs. Just saying. Specifically, he spoke to how antipsychotics could cause movement disorders. And shocking doesn't? Brain damage. Again, shocking doesn't? And death. Seriously, shocking. And we're more likely to do so the longer that an individual used them. Again, GED. Furthermore, they did not guarantee a lack of aggression in patients who took them, as was the case with Andre, who Dr. Riley said was restrained 20 times at the JRC while still on Respirato because of his aggressive behaviors. You mean the fact that he was rebelling against the fact that you were removing food, amongst other things? The fight response is real, people. Just saying. As part of Andre's treatment plan, therefore, Dr. Riley had begun to taper him off Respirato and had added a warning in the notes for the staff to be aware of the signs of medication withdrawal. Did you punish him for that too? Probably. Meanwhile, because of Andre's aggressive and otherwise targeted behaviors, a court-approved JRC's treatment plan for Andre that included the use of adversives. According to Dr. Wiley, the psychiatrist reviewing the plan had found no contradictions for their use, and the court had no problem approving it. Systematic ableism is a thing, folks. You're seeing it here. You can even quote me on that. Even with Andre's diagnosis of psychosis from a prior residential program. When asked further about this, he elaborated that Andre had not had enough psychotic features for a formal diagnosis, hence the not otherwise specified label. In any case, one could have some psychotic features while still being in touch with reality. Based on the motion from earlier in the day, Mr. Hinchy and Dr. Riley discussed the fact that the latter could and, in fact, had added new targeted behaviors to the treatment plan for the purposes of aversive use. Specifically, in June of 2002, Dr. Riley had added both full-body tense-ups, sick, and throw self to the floor. Really? To protect himself from shocks. My God. As targeted behaviors under the category of health dangerous or self-injurious behaviors. To get away from you! It's hard to get through this, folks, but work with me here. He testified that he had observed Andre engaging in them repeatedly. Gee, I wonder why. And I had to come to the conclusion that there was certainly a possibility that he could harm himself in doing so. Not any worse than what you were already doing. Just saying. As for his involvement in the incident on the 25th of October 2002 itself, he was called in to check on Andre and the situation unfolding once Andre had been shot 10 times. He had seen Andre 2 days before, and though they had not interacted, he had thought that Andre had seemed fine enough. When coming to check on Andre on the 25th, he also did not interact directly with Andre. Of course he didn't. Instead, seeking information from his case manager and other direct care staff. Negligence. His reason for doing this, he stated, was that he did not want to encourage Andre to engage in further inappropriate behavior by giving him attention, even if it was negative attention. Why is this place still open? I kind of want to burn it to the ground. It was his understanding from talking with staff that Andre was being restrained to maintain safety. Really? However, it became clear from his observation that the presence of and restraint by direct care providers was agitating Andre. His solution to the stress Andre was experiencing and alleged danger he posed was to isolate him by putting him on the 4-point restraint board in hopes that he would calm down. Again, would strapping you to a 4-point board and continuing to shock you calm you down? How is this place open? Even though Andre protested vehemently when the restraint board was brought in, Dr. Wiley's estimation its use was a success in terms of what the staff was attempting to accomplish. What? You evil. A success? You call that a success? I'm sorry, guys. Sometimes this is extremely difficult. He reported that when he left that day, at the end of his shift, Andre was doing reasonably well. I kind of want to kill this guy. His behaviors were decreasing, and he was getting relatively few shocks. Even though on the videotape he was still struggling in the restraint, sobbing and repeatedly saying the word no, Dr. Riley's reading of the situation was that he was at least no longer growling and he was starting to relax. This, he said, mirrored past incidents where Andre had calmed down over a span of 1 or 2 hours when placed on a 4-point mechanical restraint board after being physically restrained by staff. This is sick. By the time that Dr. Riley left that day, Andre received 15 skin shocks. Dr. Riley defended these shocks as appropriate, as Andre was continuing to engage in violent full-body tense-ups. Violent? How are they violent? He was being shocked. Which which he described in terms of their extent and appearance in an outside observer in order to emphasize the purported need for more shocks. Based on the parts of the video, namely Andre's apologizing at one point for tensing up and begging the staff not to shock him and asking staff to untie his shoes while being manually restrained so he would be more comfortable, the witness concluded a reasonable degree of medical certainty that Andre had been aware of his surroundings and situation, thus able to learn from the use of adversives. This is disgusting. What was he supposed to learn? That this is what he deserves? Because of his diagnosis, was that the lesson he was supposed to learn? Evil. Sorry. Dr. Wiley testified that before leaving the JRC on the day of the incident, he had checked in with a senior member of staff and told him to call if anything went wrong with Andre. He had heard later that day that Dr. Robert Van Hine, another defendant in the case, had been handling the situation, but otherwise heard nothing to suggest that things had gone wrong. It wasn't till he returned to the JRC the following Wednesday, after Andre had already been taken to the hospital, that he learned of everything that had happened. In his opinion, he had complied with the standard of care. Yeah, right. Sure you did. And had in fact tried as hard as he could to understand Andre's behaviors. No, you didn't. No, you didn't. You would have found out what triggered the behaviors, not tortured him. He had not, he said, been trying to treat psychosis, but had instead been treating disruptive behavioral problems, and use of adversives was, to his mind, the least restrictive and most beneficial way of doing so. More than psychiatric drugs, at least. At the end of his testimony, he stated he did everything he could for Andre, except the most logical, least damaging thing ever. Find what was triggering the behaviors, solve the problem. God. Ugh. After direct examination, the court took a break and I had to leave for the day, but cross-examination began and ran for approximately an hour before the court adjourned for the day. The cross-examination continued the following day. However, before more questioning resumed, and before the jury was even brought in, the parties approached the bench to speak with the judge outside of the earshot of the cameras and trial observers for approximately 30 to 45 minutes. Following this discussion, the jurors were brought in, and the judge instructed them to disregard questions about an unrelated issue raised by Mr. Novotny on cross-examination the previous day. The judge characterized these questions as unfair, highly inflammatory, and having brought potential to distract and informed the jury plaintiff's counsel had been admonished for his conduct. Finally, she reminded them that the only potentially negligent conduct at issue on the part of the JRC or any of its employees was the treatment of Andre on the 25th of October, 2002. According to the reporter from Fox News, the issue raised by Mr. Novotny had to do with student deaths at the JRC. I would think that was extremely relevant. But I'm just an autistic girl with some common sense. Mr. Novotny's questioning of Dr. Riley resumed with the attorney asking about records that included observations about Andre by treatment professionals at other residential programs, with particular emphasis on those from Woods Services, the program which Andre had been attending prior to placement at the JRC. Dr. Riley characterized Andre's prior treatment as being without success, saying that Andre's behaviors had continued to deteriorate at other programs. This is why ABA doesn't work. Mr. Novotny countered this by introducing into evidence parts of Andre's records in which a care provider had written that the Woods Services program had been benefiting him. These records went on to say that Andre should have been considered for a less restrictive program because of the low incidence of his engaging in dangerous behaviors. Thank you! The JRC's own records from the period before it submitted the treatment plan to the probate court also contradict Dr. Riley's affidavit. Specifically, in approximately 4 weeks leading up to his drafting and signing the document, entries in the record stated that Andre had no instances of aggressive behavior since he was put temporarily back on Risperdal, and that he was stable and doing well. There was apparently a number of other stability and good behavior related entries that did not get directly quoted from during this period. Mr. Novotny went on to introduce and discuss a form used at the JRC that stated whether, according to staff, psychiatrists worked with Andre, the use of aversive procedures was contradicted for him. The instructions at the top of the form established that there was no contradictions for a given aversive procedure if the psychiatrist wrote his initials next to where it was listed on the page, and conversely, that the absence of initials next to a given intervention meant that it was contraindicated. This form, which was dated the 4th of April 2002, excuse me, and which was in effect of October the 25th of that year, revealed that the psychiatrist had approved of the use of aversives, including restraint, electric shock, restraint helmet, meal restrictions, and being sprayed with water on Andre. Oh my God. However, the psychiatrist had not written his initials in the space to where the combination interventions, which included use of electric shock and a restraint helmet simultaneously on someone who is physically or mechanically restrained, was listed. This is horrifying. Oh my God. When asked, Dr. Riley stated that using an aversive that is indicated for a student is against JRC policy. He stated that he did not know why the psychiatrist had failed to initial that part of the form. On redirect examination by attorney Edward Hinchy, Dr. Rayleigh stated that he did not actually know if the particular authorization sheet was in effect of the date of the incident. He mentioned there was no comments on the sheet explaining why, at this point, the psychiatrist had concluded that the combination interventions were contraindicated, and that the psychiatrist never discussed the change with him. As far as he was concerned, no one had ever suggested that these procedures were no longer appropriate for Andre. A brief recross-examination by Mr. Novotny later established that the form did not require a psychiatrist to make comments about why a given aversive was contraindicated, stating only that such a contraindication may be explained. In addition to the early parts of cross-examination on redirect, he stated in drafting Andre's treatment plan and the affidavit to the probate court that he had not reviewed the records from the Woods program, even though, as established on recross, he had access to them. With regards to the JRC records for the period leading up to the probate court hearing, he said that during that time, Andre had good days, even good weeks, only to be unpredictably aggressive and self-injurious at other times. You just want an excuse. You just want an excuse. Lastly, he testified that he did not have any information on Andre's sexual abuse history in the records he used in developing a treatment plan for Andre. When later asked by Mr. Novotny as to why he had not asked Mrs. McCollins whether Andre had such a history, he said he had seen no need to do so. That's called doing your due diligence, moron. Dr. Riley's testimony ended with recross examination and was followed by testimony by his own expert witness, which is covered in a subsequent blog post. Finish this out. I'm not going to do commentary on the whole thing, but in regards to what he suffered at the other center, we have these things that follow us everywhere. It's called our medical history. And it is behooving upon our doctors to familiarize themselves with our documented medical history before coming up with a treatment plan for us. Dr. Riley did not see fit, when coming up with a treatment plan using dangerous aversives, to review Andre's full medical history. That should be frightening to you. It certainly is to me. This whole reading through this today was absolutely horrifying. But I kind of commentated on it throughout the video, so there you are. I do apologize about the coughing, by the way. I'm still waiting for summer, where all these allergies can go away. It's been murder. I even have a freaking sinus headache. But anyways, folks, this is what I got for this afternoon, and we're going to go ahead and finish up the day here. As always, folks, we don't get that many views on this channel, and the few that we do get do tend to, unfortunately, get removed by YouTube. So please don't forget to hit the like button, hit subscribe, don't forget to hit the comments. Thank you for suffering through this with me. This is hard to go through, especially again. I remember when all this first came out. Thank you for being patient with me. And folks, please share this. We got to get the word out. We got to get the eyeball on this center. These kids need us. This is disgusting. I do appreciate your time, and I do hope you have a good one. See you later. Bye-bye.